Welcome to Thursday night. Hey everybody, John Skiba here from the Consumer Warrior YouTube channel. Welcome once again to Thursday night here on the channel. Each and every week, I'm here to go over questions, concerns, offer tips, strategies, all things dealing with debt collection, bankruptcy, debt collection lawsuits, and all of those types of things. If you're new to the channel, please go ahead and subscribe. We put out new videos. We're doing it 6 days a week now, putting out a lot of different information, content. And the whole reason why I started the Consumer Warrior YouTube channel is because in my law practice here in Arizona, I'm an attorney in the state of Arizona, and I've always done bankruptcy. And I was, having so many people that were filing bankruptcy, and I felt like they didn't need to, particularly against these junk debt buyer lawsuits. But sometimes it doesn't make sense to hire an attorney, and sometimes just frankly, it's not feasible. It's expensive to hire an attorney. I totally get that and understand that. And so that's why I created the Consumer Warrior YouTube channel, is to provide some resources, maybe point you in some directions. But you need to understand that's exactly what all it is. It's just some guy talking on YouTube. If you need legal advice, if you're in the state of Arizona, you can contact me. My telephone number is below. I'm happy to do a consultation if you're an Arizona resident. If not, find an attorney in your particular state, which also brings me up to a thing. So something I think a lot of you are aware of some of these, the templates and the forms and the tutorials that I put together that really do a deep dive into a lot of these things, particularly related to defending debt collection lawsuits. I've always kind of struggled with what's the best way to create kind of an online learning platform. YouTube has its limits as far as what we're able to actually do. We can do this kind of Q&A stuff, but we can't really do a deep dive thing, which is fine. So, and it's just me up here, just, yakking. We need, you can learn from each other, because there's hundreds of thousands of people that go through these lawsuits on an annual basis in the United States. And so you can learn from other people who have gone through it besides someone just like me. And so I put a link in the chat section on YouTube, a link to all the different tutorials and templates, but I've also packaged them differently in what I'm calling the Consumer Warrior University. Consumer Warrior University is different. It's much more affordable. And what I'm doing is I'm putting all of my classes, and here's like all of these are included in this. You can see, at least right now, if you're buying them individually, they run about $95 each. But you can get access to every single one of my classes, the templates, the tutorials. And not only that, you can get it through you'll become a member of the Consumer Warrior online community, where you can interact not only with me, but with other people who are going through these things. So that is much cheaper. The link's there. You can see the Consumer Warrior University. It's a subscription type thing. Cancel it at any time. So if you need it for a month, great. Then you can be done. If you need it for 2 or 3 months while the lawsuit's pending, you get instant access to all of the classes that I've ever created. Not just an individual, but all of them, all the forums. And there's roughly 20 of them. You're going to get access to the ones I am creating that are going to be released in the near future, particularly the ones that deal with private arbitration. So just go check that out and see if that could be a benefit as well. All right, let's how we do this each week. If you have a question, if you're on YouTube, go ahead and put that question in the chat section. I'll put it up here on the screen and we'll talk about it. Lois was here bright and early, so let's take her question first. Lois says, why would a judge overrule arbitration on a credit card lawsuit of $3,000? I offered to settle $1,000, but they said they're only taking $3,000 on a credit card suit of $3,600. If your question, I want to make sure I'm answering the right question. If the question is, if you filed like a motion to compel private arbitration, which is a strategy I recommend that people do frequently, it's a good option. If you're saying, why would the judge deny that? The judges don't deny it because of the amounts involved, or frankly, I don't understand the reasoning behind why the judges do it. Most judges are overworked. They have way too many cases, and you think they would be happy to get rid of a case where there is a legal basis to do so. When you're asking the court to kick a case out of court and put it into private arbitration, you have to have a private arbitration clause. That's found in the terms and conditions of the credit card agreement. So again, check out one of the tutorial. I go through a deep dive. I have a form and a template that shows you how to do this. But Lois, I don't. It's something where I don't. Some of the judges maybe feel like maybe they're not familiar with it. Maybe they're not understanding the reasoning why. And that's why it's important to really articulate what the agreement is. You're just trying to have the court enforce the agreement that the credit card company or the junk debt buyer who has stepped into the shoes of that credit card company of what they would like. It's their agreement. You're just asking the court to enforce their agreement. So, hey, we love comments like Daniel here. No questions today. Just wanted to thank you. Thanks to this program, I had been able to battle and win at court. Awesome. Nice work, Daniel. Thank you for being here. I'm glad that it was helpful. And this is Daniel. This is why I do it. And so I appreciate that right now. All right, let's talk to Monterey MX. I have a Bank of America jury trial coming up in Texas. Jury trial. This is big time. The attorney for the plaintiff is based in Ohio. Can I object to the business records as evidence if they send a local appearance attorney who can't verify? It's a good question. And it's important to remember attorneys cannot testify. Like an attorney cannot go to court, particularly in a jury trial. An attorney cannot testify about the authenticity of documents. They need to have someone there who created, maintained the records, a custodian of records from the entity that actually created the documents. And if it's this is Bank of America, Bank of America needs to have somebody who's an employee of Bank of America, not their attorney. The attorneys don't have any specialized knowledge. They're hired guns. They just work for Bank of America as their attorney. Something that's important to know, and this is kind of advanced level stuff, but if you are doing a jury trial, the whole issues of admissibility of evidence is usually dealt with prior to the trial, prior to even the day of trial, with something called a motion in limine. A motion in limine is filed with the court saying, hey, judge, I don't think the Bank of America should even be able to introduce these documents because they haven't disclosed a witness or they haven't done, X, Y, and Z. If the court overrules that and then says, no, they can go ahead and do that, you can still raise the objection. Judges are much more strict as far as what comes in and what doesn't when there's a jury involved. The judge's role changes considerably in a jury trial. Like in a bench trial where the judge is the one who's reviewing the evidence, making the decision, making the final call, sometimes they'll say, oh, I'll admit the evidence, even though I think it's a little sketchy, and then we'll give it the weight it deserves, is what they always say. But in a jury trial, the judge's role is more of like an umpire. The jury is the one who has to decide whether there's liability or not. And so the judge's role there is to determine if what information or what documents or what evidence gets to the jury. And so they're usually a lot more strict when it comes to a jury trial than they are in a bench trial. So. All right. Margaret says portfolio. I'm assuming Portfolio Recovery Associates is doing a soft check on my credit every other month. Since November, both the accounts are outside the statute of limitations. It will turn 7 years in 2025. I'm wondering what they're up to. If they're checking your report like that, they're looking for information. They're looking for, you ought to really, let me see, both accounts are outside the statute of limitations, 7 years in 2025. So if they're outside the statute, then you might, what they're looking for usually is to see if there's some change in circumstance that would allow them to pursue it. They may not be recognizing that it's outside the statute of limitations. Usually the soft checks like that don't impact your credit score, but it's something to be aware of. They're up to something. They don't do that just to do it. Although what a lot of people are surprised to learn is the credit reporting agencies, TransUnion, Equifax, Experian, they sell something called a trigger report. And what this is creditors like Portfolio Recovery, they can buy these reports and they get these reports anytime there's something on your report that triggers, like you bought a house, you bought a car. There's something that's making it so that this report is coming to them. So they may be getting something back that's telling them there's some changing circumstance in your situation. But if it's outside the statute, even if they do file suit, you can file a motion to dismiss and probably get fees on that. So, all right, let's see here. Randall, one of our regulars. Have I had a lot of success with Chase and Jams? Filed for a client and they're stalling on paying the arbitration fees. Full transparency, I've had only 2 or 3 where they've even proceeded past us filing the filing fee and filing the initial request for arbitration. My situations are almost always they drop it. They just dismiss. They don't want to do it. So if they're not paying the arbitration fees, then you can contact Jams and say, this should be dismissed then. And then if it's dismissed, particularly if there's a lawsuit that's still filed, you can go back and say, look, I initiated it. They're not paying the filing fees. Or maybe they initiated it and they're not paying it, so it was dismissed. That would be the basis of getting a motion to dismiss with prejudice from the court and from the arbitration process. All right. MCATs, glad to catch you live. Great. I'm glad you're able to as well. I had to stop paying my credit cards in December 2022. I only received Social Security income and for years was able to pay the minimum payments, but not anymore. What should I do? So I think in situations like this, what I like to do is make sure that it's clear kind of what the collection cycle is and then what creditors can and can't do. So for instance, in your situation, you have credit cards, you stopped paying them 6 weeks ago, 8 weeks ago. Now they're in this initial collection status. They'll do some internal collections. They might hire an outside collection agency. They're calling. They might be emailing. They might be sending stuff like that. And then after about 90 days, they may bring it back in-house or they may find another collection agency and keep trying to do that. After 180 days, 6 months of no payments, the law requires that they charge off the account. Now, charge off does not mean that they can't still try to continue and collect on it. I'll keep saying it over and over, no matter all the hate trolling type stuff I get online every time I say it. If a debt is charged off, they can continue to collect on it. It's an internal tax classification. They're counting as a loss on their books, but they can either package it up and sell it to a junk debt buyer like Midland or Portfolio, one of those guys, or they can continue to do their own collections. They can even file a lawsuit on it. So charge off, we need to kind of adjust the thinking because it sounds like, oh, they charged it off. I guess it's, they're not able to collect. They're still able to collect on it. So, and then they may file a lawsuit to get a judgment against you. And the reason why they want to get a judgment is they want to garnish your wages, or they want to garnish your bank account, or they may even want to try to lien property. So that's kind of what collectors do in general. Now, it's important to know in situations like Kat's here, some income is protected. It's exempt under federal law, and under almost every state law, it's exempt. So it's like in your situation, Social Security under federal law is exempt. They can't garnish it. And even if it's in a bank account, as long as it hasn't been commingled with other types of income, it's exempt. So the question you'd have to find out is what else can they do to you in your state? Like in Arizona, where I practice law, they could record it, a judgment, and it would act as a lien against any real estate in that particular county. But there is a homestead exemption, so there may not even be a whole lot they can do there unless you sell or refinance or something like that. So if you're in a situation where there's Social Security, there's minimum income, it's important to understand you're in a better position than maybe it feels like. They try to be loud and scary because that's really about all they can do. They can't do a whole lot to you. I would recommend you contact an attorney in your particular state. Make sure what your exemptions are. If you're in Arizona, you can reach out to my office. My little phone number thing is going along the bottom there. And I'd be happy to talk to you. We could kind of talk about details. But if you're not in Arizona, I'd contact someone who knows the exemptions in your particular state. So, all right, let's see what else we got here. Al, thank you every week supporting the channel. I sincerely appreciate that. My man Alex, support from Yuma, Arizona. My folks were just here. My parents live in Utah, and they do this. They come down to Quartzsite, Arizona in the summer or in the winter. They're part of these snowbirds. Quartzsite, Arizona is nothing but just dirt. It's a town of like, I don't know, 1,000 people all year. And then in the winter, all the snowbirds descend in their motorhomes and they park it in that you just park out in the desert and you stay there for a month. I said it's kind of like Burning Man for retired people. I keep telling my parents that. We were just out there last week. I bring this up because Alex is bringing, they also drive down to Yuma. Quartzsite's only about an hour and a half from Yuma, which is also near Glamis Sand Dunes. My family are big sand dunes people, and so they drove down there to see that. That's not what you came to hear. Let's talk about your question. Alex says, does a junk debt buyer have to prove that they purchased your specific account from the original creditor? Yes. So, a lot of times I see people when they come into my office here in Arizona, they give up because the initial disclosures come in or the documents attached to the complaint and the summons that they're saying, oh, look, they've got this general assignment, this general bill of sale. It's one thing to say, okay, that here's showing that your particular account was transferred. But if they're just saying a general group of accounts was transferred, as one judge told me once, how is this even relevant to this case? If it doesn't have your particular account number, your name on it, how is it that is it even relevant to the proceedings? The judge was asking that sincerely, saying, I don't see how this connects to anything that we're doing here today. So absolutely great question. You got to have that on there. Let's see here. William Lee says, is an arbitration clause for legal issues that may arise out of a contract still enforceable even after bankruptcy? So if you were to, if the contract, if we're talking about a credit card agreement that you had prior to bankruptcy, you go into a Chapter 7 bankruptcy, it's successfully discharged, meaning the debts are legally eliminated, then no. They shouldn't be collecting on the debt, period. It'd be a violation of the discharge order, and it essentially eliminates that contract. I don't know if I'm answering the right question that you're seeking there, but typically no. If it's if a contract is entered into after a bankruptcy case is filed, after a Chapter 7 is filed, then you're in a situation where it's different, because any contracts entered after are still binding even after the fact. So Randman Sports Card says, is Chapter 7 bankruptcy worth filing for less than $10,000 of debt? And you've got a follow-up question here saying, will most courts in Arizona arrest you in contempt for not showing up to a debt hearing? Let's talk about the first question first. There is no specific dollar amount that you need to file Chapter 7 bankruptcy. There's some practicalities to it. I mean, there's a cost associated with it. Attorney's fees are usually anywhere from $2,000 to $3,000 to do a Chapter 7 bankruptcy. The court's filing fee right now is $338. Firms like my office, we do our Chapter 7s on a payment plan, like we stretch it out over 12 payments. So it's a little bit easier. But really what I look at, if someone comes into my office and the debt is anywhere near 10 grand, or particularly even if it's less, I look at their ability to pay. If someone comes in and they're on Social Security disability, they're getting, $1,000 a month and they're barely able to put groceries on the table kind of thing, then yeah, I have filed, I think probably the lowest I have filed is a client who had about $9,000 in unsecured credit card debt. But it might as well have been $9 million, because there was zero chance they were ever going to be able to pay that back based upon their personal circumstances. There's also some other considerations I look at. Are you getting sued? Are you getting garnished? Is there some kind of lien, or is there something where, maybe there's only $10,000 of debt, but they're taking 25% of your check, and it's making it so you can't literally pay the rent. You can't buy groceries for your kids, that kind of thing. Then we look more at the bankruptcy makes more sense. But, I've always said, I've seen situations where $10,000, it's absolutely necessary. I've had clients who have $100,000 in credit card debt where I'm like, if there's sufficient income here, we could probably do something other than bankruptcy. And that's one thing that surprises a lot of people when they come to me. Bankruptcy is not always the best option. I don't think it is. And so there's times where we'll go over, let's look at some non-bankruptcy options on how to deal with this. Now, your follow-up question, as far as will most courts in Arizona arrest you for contempt for not showing up in a debt hearing? the arrest only comes into play. We talked about this, I think, a little bit last week on the live stream. The only time you're going to go to jail, and let's set aside child support, taxes, you're going to go to jail if you don't pay those. But a credit card, you don't go to jail for not paying a credit card. Even if they sue you and get a judgment against you, just because you can't pay it doesn't mean that you are going to go to jail. What happens is once a judgment is entered, in most states, the creditor is able to do what's called a judgment debtor's exam. And so the judgment debtor's exam can be like a deposition in an attorney's office. Here in Arizona, they even do them before the judicial commissioners, where you have to actually go into the courthouse, and then they'll ask you questions about your assets. If you don't show up, whether it be in a courthouse or like a deposition type thing, if you don't show up, then the other side can go in and ask the court to enter what's called a civil arrest warrant. And the civil arrest warrant, they're not coming in, knocking down your door, dragging you out of your house and arresting you. It's one of these things, if they come upon you, if you get pulled over for speeding and there's a civil arrest warrant, absolutely. I've seen it happen. They'll take you into custody, take you down to jail, and then say, hey, you got to provide these documents, and then we'll let you out. That kind of, it's not, you're not going to spend weeks in jail or anything, but best to avoid it. Let's just say that. And so I would highly recommend going to those. I'd recommend you have an attorney go with you as well, just to make sure as far as what information needs to be disclosed. But absolutely, that you're getting in the jail side of it is really because you're in contempt of court. The court ordered you to appear for this judgment debtor's exam, and you ignored it, or you didn't show up, or you didn't have if you don't show up because there's a good reason, if you're in the hospital or some, death in the family, you need to let the court know what happened so that they don't issue that arrest warrant, or if they do, that they quash it. So that's typically how that plays out. Okay. Marco says, I was granted. Marco, I saw your comments on the chat. I have your comment. I was going to use one of them as my thing. So I'm glad you're here tonight. You were granted private arbitration. However, I was ordered to initiate it and file it myself and let the junk debt buyer know. Does that mean that they don't have to pay their fees? It's a great question. And this is actually one of the tutorials I'm adding to this Consumer Warrior University, where you'll have full access to all of them. But this is going to be kind of an add-on course that's part of that whole group to those who subscribe to it. If the judge, and I won't, you can go back and watch past live streams. I've talked at length as far as why I think the creditor needs to be the one to initiate it. But let's say you're in a situation like Marco, and the judge is like, no, if you want to go to private arbitration, you've got to initiate it. I would recommend you do that. So whether it's through JAMS or the AAA, American Arbitration Association, you can still go there. You can initiate it. It's fairly straightforward. Like I said, I'm preparing a tutorial on it right now, how to do it. You're going to have to pay your filing fee, which is in the $200-ish range. But the other side, they're still going to have to pay not only their filing fees, they're going to have to pay the arbitrator fees. Their fees are huge. They're thousands of dollars. So just because you're initiating it doesn't mean that they don't have to still pay their fees. Just like if they were to be the ones who initiated arbitration, you would still have to pay your $200 filing fee. The filing fees are just different. The private companies, AAA and JAMS, they set the fees. These are just private companies, and they say if it's a business and a consumer thing, they're going to pay a whole lot more to do this than they are if you're the consumer. So, all right, let's see here. Oh, this is a follow-up from MCATs. I spoke to a debt management, and they said the banks and collectors cannot do anything to me. I'm worried as I cannot afford even to pay the filing fee with the court once the banks sue me. And it's good that you're talking to people. Like I said, I would reach out to an attorney in your state and talk to someone who knows the exemption laws and that specifically, and can look at your property situation and give you some specific legal advice. There are situations where people are judgment proof, meaning that you can't, even with the judgment, they can't do anything with it. And so I would take a look at that. If it's something, like I said, if money is so tight that this is, Dave Ramsey calls it the four walls. If you're not able to deal with the four walls, rent, groceries, utilities, that kind of stuff, you need to look at, is it an acceptable strategy just to do nothing and tell them to pound sand? But before doing that, I always recommend you at least talk to someone. So, All right, let's see here. Let's see what Anne Marie has to say. My mom owes a large sum of money to her HOA with inflated interest and attorney's fees. Would she be able to settle in court? Anne Marie, I'm going to tell you something. HOA cases in the state of Arizona are my least favorite. The reason is in our state, in Arizona, the HOAs have the laws that protect HOAs are insane as far as how they protect them. And so often they don't settle because they know that the laws are very strong. And if you, for example, in Arizona, if you don't pay your HOA fees, there's an automatic lien that's attached to your home. They don't even have to sue you. Just by operation of law, they have a lien against you. So it's tough to settle. I always say, if at the end of the day, a creditor wants money and you're offering money, there's got to be some kind of deal that can be reached. You just don't generally get that big of a discount on it. So, all right, let's see here. Dominica says, good evening. I have currently getting garnished every payday. I was served by mail and the debt went into default. Should I just do debt consolidation? What other options can I consider? If there's an active garnishment like you're dealing with, which is, I know, incredibly difficult, settlement is usually pretty tough unless you have a lump sum amount that you can then provide to your creditors. So, if they have a $10,000 judgment and they have a garnishment, all the leverage is in their corner now. And, you're going to have to come in and probably offer 95. You're going to have to offer something in a pretty big lump sum. Otherwise, they'll just tell you to pound sand and keep taking your pay, which is unfortunate, but that's what they're going to do. Really, the only way to completely just stop a bankruptcy or to stop a garnishment is to look at bankruptcy. Like a Chapter 7 bankruptcy, as soon as that petition is filed with the court, the judge kicks out an order called the automatic stay. It's literally automatic. We file these cases electronically, and we can just download the order. It has electronic signature from your judge, and that's mailed out to your creditors. And from that moment, the garnishment has to stop. So unfortunately, if it gets to that situation, I often end up recommending a bankruptcy. So, all right. Mad Max says, haven't worked for 2 years. I have nothing much and no income. And I showed the judge, said, I'm not in default judgment, but the creditor can try and garnish wages when I'm healthy enough to get a job. So, so the situation there is this is why, going back to MCAT's question, why I say, even if you're like, hey, I know I'm judgment proof, they can't do anything right now, I recommend talking to an attorney about that. The reason is because exactly what you're dealing with here. So right now in this time frame, they can't do anything. If you're not employed, there's nothing to garnish. There's no, if there's no real estate, there's nothing like that. Then you're in a situation where, where they can't take anything. But like in Arizona, a civil judgment is good for 10 years, and then it can be renewed for 10 years indefinitely until the day you die. They can just keep renewing this thing and churning interest on it, and they do it. I see clients get garnished, in a 2005 type judgment that's just been sitting out there. And so if your situation may change going forward, that's what you need to be careful of. What you need to be really considerate of is that if you're in a situation where, hey, it's permanent, I know there's a disability issue or my income is not going to change. But if you're going to get a job down the road, all of a sudden they may show up at the worst imaginable time, right? As you get this new job or something like that. So that's where you got to be really careful with that. So, all right, let's see here. Oh, Randman said, currently unemployed, but Citibank sued me for $2,600. If I'm not working, what happens? Just right along what I was saying there. They can't, if you're not working, they could look to see if you have money in a bank account. That's kind of just a fishing expedition. It's hard for them to know what's in your account unless they actually subpoena that information. But the concern is down the road, what they might be able to do. Tony says, do junk debt buyers go to court over $800? I was served, but I can't believe they would pay for lawyers and take me to court over $800. This is a good question, and it's kind of a fascinating thing. I've talked to the attorneys for a lot of the junk debt buyers here in the Phoenix area, and because you would think it's exactly backwards of what you think. If you're thinking, okay, here's this $25,000, $50,000 credit card, of course they're going to sue me. They're not just going to let that thing slide. But like Tony saying here, $800, are they really going to sue me over this? And here's the thought process of many of these junk debt buyers. If you get sued for $50,000 or a $60,000 or $100,000 credit card, most people are going to file for bankruptcy. So they know if they jump in with this lawsuit, they're probably not going to collect on it. They're going to get a bankruptcy filing eventually. But for $800, they know you're not going to file bankruptcy over $800. I just told you the filing fee is $338, but they know they're going to get some kind of settlement out of this. So they're either going to get a settlement and be able to make it to go away, or alternatively, sometimes these $800 things, if they go to default, all of a sudden then they add prejudgment interest, they add attorney's fees, and this $800 lawsuit turns into $4,000 judgment, and then it's good for 10 years, and they just let it keep growing and growing and growing. So that you're actually more likely to get sued for something that seems just ridiculous, as opposed to maybe some of these bigger ones that are out here. So, all right, let's see what else we got here. Scan through these. Sorry, there's a lot. I'm kind of trying to get through these. We'll do one more. I went to the Marine base, widow of a military. I thought that would help. Nope. So I'm just under 13 to a debt collector. They just served me on January 30th. What can I do? So if you're on a base, I guess what you're saying is you went to the JAG officers and they said they wouldn't help you. Just surprising. I thought they would. If they're not willing to help you and that you just got served, what I'd recommend, the main thing, like I said, 95% of people who get sued by a debt collector, the biggest mistake they make is they don't do anything and they let it go to default. And then the issue is, like I said, like before, that $800 credit, account just balloons up because they go and add interest on it, they add attorney's fees, and it just gets out of control. And so my recommendation, there's three options with any kind of lawsuit. You can fight it, you can settle it, you can file bankruptcy on it. That's it. Those are your three options. Sometimes there's the fourth, the pinky option, the do nothing that we were talking about earlier, but you got to be careful with that. So the three options: fight it, settle it, or file bankruptcy on it. I would recommend, you can reach out and try to settle it for $1,300. They might be willing to take $600, $900. If it can be done in a lump sum, they might take some payments over time while you try to get it worked out. So that's the settlement option. And I usually settlement is not a bad thing to engage in these kind of cases. Settlement discussions are generally not admissible in court. It's Rule 408 under the rules of evidence in most states. And the reason is the courts want the party. They want to encourage the parties to talk and try to resolve the dispute rather than going to court. So they want to encourage that, so they can't use that against you. So Sylvia, if you reach out and say, hey, I'll offer you $500 to get this thing to go away, they can't turn around to the court and say, she offered us $500. Clearly she owes the whole thing. They can't do that. So sometimes I say, especially early on, if you just get served, call up their attorney, and you're gonna have to go through their attorney. I get that question a lot too. Can I just call the original creditor or the debt buyer? No, you're gonna have to go through their attorney and just say, hey, I'll pay you $500. I wouldn't give them information. I wouldn't give them any kind of, information. You can request more time. Depending on which state you're in, like in Arizona, the parties stipulate all the time for, hey, can we get another 30 days while we try to negotiate something out? And they want, most debt collection firms, it's just usually a handful of attorneys and they have thousands of cases. They want these things to settle. They don't want it to continue to litigate it. But you can check the Consumer Warrior tutorials, that Consumer Warrior University. I have a bunch of templates on how to respond to a debt collection lawsuit, and some of the strategies behind that can kind of go into a really deep dive. And you are in Yuma, so man, you just got to check out Alex. Alex knows all this stuff. But yeah, so the tutorials work for any state. Frankly, they're just kind of some general principles and forms. But you can check that out. But you can request additional time as well. You're probably dealing with one of the law firms I work with all the time, and so you could reach out to them and see exactly, ask them for a stipulation to extend the time. Something in Arizona that's Arizona specific. In most states, if they give you 20 days to file an answer. But if you don't, a default is entered automatically. In Arizona, there's a two-step process. They have to file an application for entry of default after 20 days, and then the court gives you 10 more business days. It's kind of like a built-in grace period of sorts. So you may want to take a look at that and see if you can. So what I'm trying to say is they're not going to be able to surprise you with the default. You'd have to be right involved in there. So, all right, last question. Randman, I'm not going to leave you hanging. We'll get this one. I'm a stay-at-home dad to take care of my son who was just diagnosed with autism. So I'm literally unemployed and can't afford to proceed with the lawsuit. Am I judgment proof? So judgment proof, what that refers to is if they sue you and get a judgment, is there anything they can take from you? How much pain can they cause with this judgment? They can damage your credit. They can be annoying with it, but can they take anything? Can they take your wages? If you're not employed, there's nothing to take. They can't, so they wouldn't be able to take your, there's no pay. You would need to see, do you have money in the bank? If you have savings account, something like that, they could come in and get a writ of garnishment or a levy and try to take money out of the bank account. That's a possibility. If there's no money in the bank account, then they can't. Or if the only money in there is like Social Security, they can't touch it. Do you own real estate? If you don't own any real estate, there's nothing for them to lien. If you own a rental, if you own a home, or if you have like vacant land, they can record a judgment that can act as a lien against it. So you kind of go through and check the box. Is there anything they can take? There's a vehicle exemption in most states. Household exemptions are protected. Retirement accounts are protected. That's what you really, the analysis you have to go through is try and determine, and like you were saying right here, you have no assets, honest truth, fiance's vehicle. Yeah, it sounds like it would be very difficult for them to collect. My little asterisk to this whole thing is you've got to be careful. You got to be careful because if the situation changes, and I know right now, especially, they're putting a lot of pressure on you and that's what they want because they want you to offer them some money. If you don't have it, then there may not be a whole lot they can do to you, but it's possible, down the road, it could be, become an issue. So, all righty, let's see. I will do one more. In Chapter 7, bankruptcy, we voluntarily surrendered a motorcycle. Can we pay it and keep it after the bankruptcy discharge? So I'm assuming what that is. If you still have it, yeah, I mean, they should. If you're going, this is totally up to the lender. If you're current on it, you still have it. I mean, if you've surrendered it, they're not going to give it back. But if you have it, you can keep paying on it if the lender allows you to do that. Sometimes you have to enter into a reaffirmation agreement. I can tell you more and more in Arizona, the courts are they're not approving the reaffirmation agreements. They're just telling you to pay it and keep making the payments, and you can keep it and pay it off. So that shouldn't be an issue. All right, that's going to do it for tonight. But hey, thank you for everybody for tuning in. And again, if you haven't subscribed, please do subscribe to the channel. I appreciate that. I appreciate all the support we get for the regulars who are here each and every week. And go check out the Consumer Warrior University. The more people we have in there, the better, because like we're seeing here in the chat section, a lot of people have been through these things. They know what they can, what would be a benefit to help each other out. I'm involved in there. You're going to get full access to all the tutorials and a lot of the videos that we don't put here on YouTube. So go check that out. I think it could be a big help. There's no commitment to do it over time. You could just do it for a month if that's a benefit. So hopefully that helps you out. I do appreciate you checking in tonight. We'll catch you next.